Hello, welcome to the show. Today we will discuss the interplay between litigation trusts and structured settlements. My guest today is Thomas D. Begley Jr., a certified elder law attorney of the Begley Law Group in Morristown, New Jersey. He focuses his practice on disability law, elder law, and personal injury consulting. He is a founding member and past president of the Special Needs Alliance, a national organization comprised of attorneys committed to helping individuals with disabilities, their families, and the professionals who serve them. Tom, let's start off by going over the different types of litigation trusts.
All right, there are 5 types of trusts commonly used in the settlement of personal injury litigation. One is a self-settled special needs trust, and that has to be funded with assets of the individual, which it is because they're the person receiving the settlement. Big problem sometimes is that people have to be under age 65. The trust has to be for the sole benefit of the disabled plaintiff, and it has to be established by the plaintiff or his or her parent, grandparent, guardian, or a court, and there has to be a Medicaid payback. So that's the self-settled special needs trust. The second type is the self-settled special needs trust, but it has Medicare set-aside provisions. Now, some people like to do the MSA outside the trust, and there is a court case that says because the assets in the MSA are restricted, that the assets in the MSA won't be counted for public benefit purposes such as SSI and Medicaid, but that's not universally accepted. So a more conservative approach is to put MSA provisions right in the settlement protection or the self-settled special needs trust. The third type is what we call a settlement protection trust, which is basically just a support trust. The person receiving the settlement would not be eligible for any public benefits, so you use that when public benefits are not required. And then the fifth and final type of litigation trust is a settlement protection trust with special needs provisions and MSA provisions. So basically there would be 3 subtrusts. So you start off by funding the MSA subtrust and the settlement protection subtrust, but if the beneficiary needs public benefits in the future, the trustee takes the funds out of the settlement protection subtrust, transfers them over to the special needs subtrust, and individual can then get SSI, Medicaid, and other means-tested public benefits.
How does one determine which type of trust to establish?
Okay, so the self-settled special needs trust is used when someone is going to need means-tested public benefits, and the 2 big ones are SSI and Medicaid. So if an individual has more than $2,000, they're not going to be eligible for SSI and Medicaid, and if they have too much income, they might not be eligible for food stamps or federally assisted housing. So in those types of cases, you use the self-settled special needs trust. We include the MSA provisions when there's going to be an MSA required in the case. We use the settlement protection trust when we don't have to worry about means-tested public benefits. And we use the settlement protection trust with special needs provisions when, let's say, we have a plaintiff who has a birth injury, so maybe they're 10 years old. They're not going to be eligible for SSI and Medicaid until they're 18 because one or both of their parents work and their parents' income is deemed to them until they're 18. So we were setting up settlement protection trusts with the idea the trustee would just move the money over to the special needs trust when the beneficiary was 18. And then the settlement protection trust with SNT and MSA provisions we use if we're going to start off with SPT, and then we think we're going to need to fund the special needs trust, and we always start off with the MSA if there's going to be an MSA.
What are the advantages of structured settlements?
The advantages of structured settlements are huge, in my opinion. One, I've believe that most, or a very high percentage, of people receiving personal injury settlements are poor people, and they're often not very sophisticated. So I've read that the average personal injury settlement lasts 3 to 5 years. And I can see that that is probably true. So one of the advantages of a structured settlement is the rated age. So if we have somebody who has a rated age who buys a structured settlement, their payment is often higher than it would be if they just put the money in a lump sum and invested it somehow and then received income from that lump sum investment. And it's guaranteed for their entire life. So if they had taken the lump sum, they would have to spend pretty cautiously so they didn't run out of money. But with the lifetime payment under the structure, they know they're going to have X number of dollars a month coming in for the rest of their lives. So the rated age often gives them a bigger monthly payment than they would get if they didn't have a rated age, and the lifetime payment guarantees there's always going to be money there. It's tax-free. That's a nice advantage. It is creditor protected, which with a lot of our people is a big thing because they don't manage money well. They get sued for whatever, and this offers them creditor protection. And the big thing is it prevents them from squandering the money. So that's something that we need to be concerned about.
So how do you determine how much of the settlement to structure?
Okay, there are two things that you need to take into consideration. We usually start off with, say, we're going to structure 50% and 50% cash. And then we go up and down either way from there. But most trustees want some lump sum, or they're not going to administer the trust. The other problem we recently ran into in New Jersey is New Jersey requires that where there's a special needs trust, the funds in the structured settlement contract contain a commutation rider, and the payee of the commutation rider has to be the Settlement Protection Trust. They do that so the state will get their payback right away. Now, we had a case not long ago where there was a CP baby. She was about 10 years old, settled the case for a lot of money, bought a structure for, I think it was about $3.4 million, $3.5 million, I guess it was, and about 2 months later died. Because of the commutation rider, the insurance company only paid about 71% of the initial premium back. So not all of the money that was paid back had to go to pay the Medicaid lien because it wasn't that big, but the parents were going to be the beneficiaries on death from the trust, and they lost over $1 million. So you got to be careful, number one, that people understand that, because if they don't, everybody involved in the settlement, the attorneys and the structure brokers, I think, could be sued for malpractice because they didn't disclose that there was a risk that needed to be dealt with. I'd just like to make one more comment, and that is the Settlement Protection Trust with special needs provisions. We've run into a problem with those documents in the last few weeks. The Dallas region of Social Security has said that the trust is invalid if it's a Settlement Protection Trust with special needs provisions unless there is a letter from Social Security determining the individual to be disabled. So when you have these trusts where the individual is disabled, but they're not eligible for SSI, generally the parents don't apply for SSI, so they don't have the determination of disability letter from Social Security. So I've always felt that as long as the person was in fact disabled when the trust was established, that was good enough. They didn't need the letter from Social Security. So we're not sure how that's going to play out. Now, the other objection that Social Security raised was that theoretically the trustee could transfer the money from the Settlement Protection Subtrust to the Special Needs Subtrust gradually so that the Medicaid payback could be avoided. Now, if the person was receiving Medicaid because of their SSI, you couldn't do that because you'd have too much money in the Settlement Protection Subtrust. But if they were receiving Medicaid under Obamacare or some other program, that would be a possibility. So you just want to take that into consideration if you're going to do a settlement protection trust with special needs provisions.
Thank you for your time today, Thomas, and thank you for watching.